Good afternoon to all. A very warm welcome to Lawvs First National Moot Court Competition 2025. We are honored to have our learned judge in the courtroom, learned Shri Gagan Narang sir.
Hi guys. Hi.
We are welcome you lordship. Before starting with the argument, we would like to brief the bench about the functioning of the courtroom. I, Omansh, will be serving you as a court master and will be assisting you with maintaining the decorum to assist the honorable bench. The court matters will act as facilitators between the bench and the council. The court master will time the arguments and intimate the bench accordingly. Your lordship, it is required to please seek our assistance whenever it is required.
Sure.
As stated in and rules of Lawvs First National Moot Court Competition 2025. Each team will get 30 minutes to present their case, including 5 minutes will be given to rebuttal and sub-rebuttal. Subject to the discretion of honorable judge, each team shall intimate the court master in regard to division of time between speakers. Only one speaker from each team shall be permitted for the rebuttal and sub-rebuttal. The order of presentation is Petitioner Speaker 1, Petitioner Speaker 2. After that, Respondent Speaker 1 and Respondent Speaker 2. Rebuttal will be Petitioner and any one of the two speakers. Sub-rebuttal is Respondent any one of the two speakers. Where sub-rebuttals will be permitted only at the discretion of the judges. The judges may exercise discretion for extending the time for oral rounds beyond the time specific in the rule book. The rule book provides that the time extension up to 2 minutes is permissible for each round. The team code for the petitioner is team code 83 and the team code for the respondent is 16. Is this okay?
Yes, sir.
Okay, sir.
Okay. The total time is 50 minutes with petitioners speaker 1 presenting their side for 10 minutes and speaker 2 for 10 minutes, where the respondent speaker 1 presenting their arguments for 10 minutes and speaker 2 for 10 minutes. Both speaker have 10 minutes each. And 5 minutes will be given for rebuttal. I now would like to seek the permission of the judge to start with the proceedings.
Yes, please.
Thank you, Lordship. Much obliged. I now request the petitioner to start with the proceedings.
Counsel seek permission to approach to the bench.
Please.
Highly obliged, your lordship. It may please the honorable court, that is the counsel representing the petitioner in the case of Govind Das and others versus State of Uttar Pradesh. The counsel argues to the permission to proceed with the facts of the instant matter.
Please, just take 2 minutes, explain the facts in brief.
Highly obliged.
Please begin. I said just take 2 minutes and start the facts. Brief. Explain the facts in brief in 2 minutes itself.
Sir, Vrindavan is a designated heritage zone. The present meter deals with the Paki Bihari Mandir corridor project. On 19 August 2022, the tragic stampede occurred, resulting in death of devotees, at least 25 injured. Regarding critical case, civilian approached Allahabad High Court under Article 226 through PIL seeking judicial intervention, prayed for the development of controlled crowd management, safe entry and exit channel, In response, the state of Uttar Pradesh proposed a large scale of, of corridor project, which involved demolition of over 300 structures and acquisition of 8 acres of land. On 20th March 2023, Allahabad High Court, in its judgment, directing the state government to initiate and execute the proposed project. The petitioner filed a SLP before Supreme Court, challenging the High Court direction. The petitioner argued that the project would result in forced evacuation
Counsel,
of
what court is this? What court is this?
Supreme Court.
So is this the SLP that you're talking about?
At yes,
Then please do just go to your facts. We know that this is the SLP that you're talking about. Then you don't need to tell the court that you approach this court in this SLP. Just give me, as I said, 2 minutes concise facts. I don't want the entire fact sheet to be read out to me. Yeah, please proceed.
sir, the petitioner argued that project would result in forced evacuation. In these, 500 small business and irreversible damage to the cultural fabric of Vrindavan. The petitioner invoked Article 300A of the Constitution. Hence, the present matter is listed before the Honorable Court.
Sure.
Sir, if the court is well aware of the facts, may I proceed with the issues?
Please.
Highly occurs, Your Lordship. Honorable Court, Issue 1 and Issue 2 will be dealt by the present Council on the same hand, and Issue 3 and Issue 4 will be dealt by the my fellow Council.
Sure.
So, the Council seek permission to proceed with the Issue 1.
Absolutely. Please.
Highly request. Issue 1 states whether the High Court amendments under Article 226 directing a particular corridor scheme amounts to impermissible micromanagement of executive policy or its constitutional valid exercise to remedy systematic failure endangering life and safety. May it please your lordship, the petitioner respectfully submit that High Court exceeds its power Article 226. The High Court has the power to protect rights, but it cannot be to beyond its limits. Matter of policy and administration are mainly for the government, not for the courts. Court interferes with government policy, managing crowds and building infrastructure and government duties. Court should not replace government decision with their own. Separation of powers. India follows separation of powers. Legislature make law.
Counsel, who are you representing?
The petitioner.
No, who's the petitioner?
Govindas and others.
Okay. Now, you asserted some certain facts about what is the power of the High Court, what is not. Do you have any reasons to say that? By what law are you saying that?
Sir, your lordship, could you repeat?
I'm just saying that you stated certain assertions that the High Court did not have powers to do certain things. So is that backed by any law? Is that backed by any statute? Or is that backed by any judgments? How, on what basis are you making those statements?
Yes, sir. In past cases, Johri Mal versus S.B. Vora says the court must respect separation of power, not like the government. So when the High Court ordered demolition and corridor construction, it went beyond its power. Public safety is government job. Ensuring safety and preventing accident is mainly the government responsibility. Courts may step in only every extreme cases, not for every routine policy decision. Courts should avoid overreach. Protecting rights is important, but court cannot run the administration. The High Court order amount to judicial overreach. Limits of Article 21. Right to life. Article 21 protects life and liberty, but it cannot go stretch too far. It does not mean the government of courts must carry out massive redevelopment projects like demolition. Safety of devotees cannot be ensured in similar ways. Example, extradition technology for ground control, festival time rules. Precedents and corrective supervision are different. The government is sitting case like MC Mehta, environmental disaster, and Vineet Narang for corruption case to justify corrupt court interference. But those are exceptional cases. Big disaster
Counsel,
and
this
corruption.
goes for all of you. If you state a law, if you state a judgment, you give that citation as well. You tell which court it is and which year it was decided, and just state the citation also. And the relevant para that you're referring to in the judgment.
May it refer please page number 18.
Sure.
Third point, precedent and or corrective supervision are discriminable.
Please proceed.
5 year best. Both those are exceptional cases, big disaster and corruption, not everyday issues like temple management or city planning. In another cases, on the same page, Aravalis Golf Club 2008, the Supreme Court warned that too much judicial activism becomes judicial overreach, and policy making is the government, not the court. So those cases do not apply here. The High
Okay.
Court ordered to policy making, not execution. The High Court told the government to build a corridor, acquire land, and relocate people. This is not just deciding a case, it's make executing government policy, which only the executive can do. In Asif Ahmed, on the same page number 18, in Asim Ahmed 1989, the court itself said judges interrupt laws government make and carry out policies. Here the High Court crossed that line. If your lordship has no further question, may I proceed with the issue number 2?
Proceed, Counsel.
Highly obliged. Issue 2. State whether reconfiguration of temple approaches allays and religious circulation routes implicates Article 25 freedom of practice and Article 26 management of religious affairs. And if so, the correct test of distinguish faithful persecution from unconstitutional interference.
Counsel, can you repeat what you stated?
So may I repeat?
Yeah, yeah. Can you just repeat what you said?
State the whether reconfiguration of temple approaches, allays, and religious circulation routes impacts Article 25, freedom of practice, and Article 26, management of religious affairs.
Okay.
And if
Go ahead, go ahead.
highly applies. Article 25 and 26 protects religious freedom strongly. People have the absolute right to practice and manage their religion without government interference. In S.R. Bombay, count your lordship page refer to the page number 19.
Sure.
In S.R. Bombay versus Union of India 1994, the court said religious freedom is scared. Changing temple approaches and allays amount to interference with religious practice, which violates the rights. The project changes how people worship. Even if rituals were not directly touched, changing access routes affects how devotees perform worship. In Shuru page 1954, on the same page number, the court said the state can regulate only secular, not religious matter. But here, the project impact core religious activities by alternating traditional access. Precedents cited by the other side do not apply here. In Islamic Farsi 1994, the issue was land possession, not interference in religious practice or access routes. So it is not relevant. Public safety cannot be an excuse to limit the religious rights. Article 21 right to life is important, but any restriction must be reasonable, necessary and the least restrictive option. The current measures are too harsh and disproportionate and they inflict on religious freedom. In Menka Gandhi versus Union of India 1978, the court said main restriction of fundamental rights
Council,
must
what
pass.
were the facts of Menka Gandhi?
The case held that the power of
No, I want to know the facts of the case, not what was held.
your lordship page number refer to the page number 14.
Sure.
The Supreme Court in Mega Gandhi versus Union of India held that any state action
Council,
limiting
please get my question. I'm asking you what was the fact in Menka Gandhi case? I'm not asking you what was held by the court. Answer my question specifically, please.
Sir, Article 21 right to life and reasonable necessity and least restrictive, disappropriate and infringement of religious freedom.
Council, do you know the facts of Menka Gandhi case that you cited?
Your Lordship, I have no idea for this.
Then please tell me the facts of the case, not the law. I know what law is laid down. I understand you know the law that is laid down. Please understand me. Please tell me the facts of the case.
Your Lordship, can you give me 2 minutes for
I can give you the time that you have. I can't give you more than that.
May I continue, Your Lordship?
Please,
Or
you can continue with the argument.
highly obliged. Abolition of Article 25 and 26, changing the temple approaches and routes interference with devotees' right to freely practice and manage religion. Religious freedom includes not just rituals inside the temple, but also access routes, processions, and congregation practice. practices. The proposed restructuring disputes long-standing worship practice. Hence, it's violate Article 25 and 26. Essential religious practices are protected. Traditional access, routes, points of entry, ways of darshan at temple like Baki Bihari Ji have been followed for centuries. They qualify as essential, and forced change in this perspective violates the constitutional guarantee.
Council, I want to understand how does a change in route change affect the power or affect a devotee's right to practice?
Your Lordship, this is a human feelings which is connected with our Lord Krishna and their Kunj Galian, that is land there. And due to this, our future generation would never be able to know our human history. In
No, how?
I think
The question again, please understand the question is how does the change in route to approaching the temple or maybe a change in the way it looks, not the inside of the temple. The government is not touching the temple per se, is it? Council, is the government touching the temple or is the government doing any changes to the temple?
no, Your Lordship, but it affects the families and business, small business, which is
No,
not.
so it might affect the family. That's a different question. But I want to understand that how does the changing in route or how does the exteriors of the temple affect the right to practice of religion? Because you invoke Article 25, 26, saying that there is a violation. How does the changing in the approach road change affect Article 25 or 26?
Your Lordship, it affects because this human nature roots points of entry because it is a human are able to their ways of darshan at temple. They are able to.
Courtmaster, what's your time?
Uh, your Lordship, may I continue for this
So
point?
the time is approx 19 minutes.
Okay. So, yeah, do you want to finish your arguments? Do you want to conclude? Yeah.
If your Lordship have no further question, may I leave the bench for my co-counsel to
Sure,
continue issue
please.
number 3 and 4.
Please.
Much obliged.
Thank you.
If I may continue from where my co-counsel left, I would be dealing with issue number 3 and 4.
Sure.
If your lordship has no further questions, may I please move on to issue number 3?
I haven't asked you any questions yet.
Highly obliged. Issue 3 states that whether the state's objectives of crowd management and public safety, Article 21, justify large-scale demolition and redesign of an organically evolved secured precinct, and when less restrictive alternatives, staggered darshan, tech-enabled flow, festival time regulation may exist. Right to life includes culture and worship. Article 21 of the Indian Constitution, right to life with dignity, also protects religious and cultural practices.
Counsel, you're saying that from your beliefs, or are you saying that from some authorities?
So I'm saying it by my belief. Yes,
Okay.
I'm also a devotee.
Counsel, I'm not talking about your devotion and I'm not questioning that either. I am just asking that right to life, Article 21 includes whatever you said it includes. Does that come from your belief, your own interpretation, or do you have any authorities to back that?
Sir, we have right.
You have what?
So we have right to life with dignity in art.
Absolutely. Right to life with dignity is covered by Article 21, well understood, but you stated certain things beyond that as well, that those are also included. I want to understand where does that understanding come from?
Sir, it comes by my belief.
Okay, so which court is this? Can I ask?
Supreme Court.
Is the Supreme Court in India sitting to judge you on your beliefs?
No, sir.
So can I, as the Supreme Court, throw this petition out, dismissing it because it's purely based on beliefs?
No, sir.
If you make an assertion in court, especially a court of constitutional nature, then at least have some backing on that.
Okay.
Please continue.
Less restrictive alternatives. Instead of breaking or destroying the place completely, the government could use easier solutions like time slots for darshans, special rules during festivals, technology system like at Tirupati and Shiri temple. So demolition is not necessary.
Okay.
Violation of Article 25, religious freedom. Changing or redesigning the temple will disturb traditional ways of worship. Courts have, courts have said that religious freedom must be protected even against the government.
Counsel, I again want to ask this. I asked your co-counsel also the same question. I'm asking you the same question. By changing the structure of a temple or by changing how the temple looks, how does the, please explain to me by facts or by law, how is the right to practice the religion being affected?
Sir, as the people believes that the Vrindavan is the area where Lord Krishna uh, divine does the divine leelas, and if the area of temple is going to demolish, then the upcoming generation is not going to aware of that.
But they are remaking it, right?
Yes.
So demolition comes, there is a house is built for a person to live. The house is demolished, house is built again in a more sophisticated, more modern way. Nobody takes away the right to live in that house. How does the right to pray or how does the right to follow the religion or follow the deity that is being followed be taken away from the people? How is Article 25 being affected in this case? Merely by a change in structure.
So because the faith of people is in the area where it is not made by the humans.
Okay, continue, Counsel.
Arbitrariness under Article 14, the government did not consult local shopkeepers or temples authorities before making changes. The law says government action must be fair, reasonable, and just not one-sided. Here, the action looks unfair and arbitrary.
Counsel, where
Harry,
does the law state that the government has to take opinion of people before doing this?
so because in Article 14 we have right to equality, and in this we also have right that if any kind of changes in the holy places taken, then government should uh, government is not able government is not able to matlab, ask the people, but they should consult them.
Is that the
And
law? Is that a law that the government should consult the people?
no, sir, but in Article 14 we have right to equality, and
How is equality being affected here?
So because they're local shopkeepers and temples, those who are living there, their livelihood will may disturb.
Council, I'll put a hypothetical scenario in front of you. You see national highways,
Yes, sir.
there are multiple shops, there are multiple outlets, petrol pumps, etc. outside on the borders. The government tomorrow decides to make a expressway.
Yes.
Okay, now when there is an expressway, there will be certain livelihood of certain people or who had those shops around which will be affected.
No, but in this, uh, Vrindavan is a designated heritage zone.
By
That's why
whom? By designated
designated heritage zone. That's
by
why.
designated heritage zone by who has designated it as heritage zone? Who designated them Vrindavan as a heritage zone?
Sir, it is also written in our Granths and Gita.
It's written in Gita that Vrindavan is a designated heritage zone in as many words.
Not properly, but
We can have a separate discussion on Gita if you want.
no.
Okay. Again, rethink. Take a minute.
Any construction here requires approval under the Ancient Monuments Sites and Remains Act 1958. However, the government has uh, sites ignored these mandatory heritage protection, which will damage sacred alleys, pilgrimage roads, and protected monuments.
Okay. Which page of your memo is this specific law put in? Can you tell me that?
Yes.
The violation of the National Heritage Act or whatever act you're talking about. Which page is the memo on?
Sorry, I did not get this.
What?
Pardon my lordship, I didn't get this point.
No, I'm asking you. You cited a law, right?
Yes.
Is that in your memo?
No.
You haven't cited this in your memo, the law.
No. No, no, sir.
You want to proceed with your next issue?
Yes.
Please do.
Heritage and environment. The temple area is heritage and must be protected. Court said the government has a duty to protect heritage sites for the public. Redevelopment could damage heritage value. If your lordship has no further questions, may I please move on to the issue number 4?
No, you want to move on to what?
Issue number 4.
Sure. Please do.
Highly obliged. Whether the absence or inadequacy of meaningful public consultation, residents, shopkeepers, religious bodies, environmental experts renders the decision-making process arbitrary under Article 14. Article 14 Protection against arbitrariness. Article 14 of the Constitution says government action must be fair, non-arbitrary and inclusive. A project cannot be justified just by saying it is for public purpose if the process lacks participation and transparency. Inadequate consultation, surveys and reports were either selective or not shared properly. Residents, shopkeepers, temple trusts and heritage experts were not given a real voice in the decision. Alternatives ignored, safer, less drastic measures like staggered darshan, regulated entry, festival time controls were available. By ignoring these, the state's action became excessive and disproportionate.
Council, I have a question. You are citing the violation of Environmental Protection Act and Prevention and Control of Pollution Act. Did you approach the NGT or the Pollution Control Board on this?
Yes,
Have you approached NGT or Pollution Control Board? What did NGT decide?
I didn't get. Please, you can repeat it.
I'm saying, did you so for violation under the uh, if there is a violation of the Environmental Protection Act, have you heard about the Environmental Protection Act?
Yes.
If there is a violation of the Environmental Protection Act, what are the forums available to you under the Act?
No, Lordship, I have no answer to this question.
Okay, proceed. Proceed, finish up your answer.
Fairness compromised. Promising compensation on rehabilitation is not enough. It cannot make up for the loss of culture, livelihoods, and heritage integrity. Conclusion: because of all this, the process is arbitrary and violates Article 14. If
Okay,
your Lordship has no further questions, may I please move on to the prayer?
please.
Highly obliged. Wherefore, in the lights of facts presented, issues raised, arguments advanced, and authorities cited, the Council, on behalf of the petitioner, humbly pray before this honourable court that it may be pleased to adjudge and declare that to allow the special leave petition filed by the petitioner to set aside the directions of the Allahabad High Court permitting the Bake Bihari Temple Corridor project to restrain the state government from carrying out large-scale demolition, land acquisition, or construction in the name of the project without meaningful consultation and exploration of less intrusive alternatives. To hold that the project in its present form violates Article 14, 25, and 26 of the Constitution by being arbitrary, disproportionate, and detrimental to the sacred character of the present, to direct the state to consider alternative measures such as staggered darshan, technological crowd regulation, and festival time management instead of irreversible structural changes. To grant any other relief deemed fit in the interest of justice, equity, and good conscience, and for this act of kindness, the petitioner shall, as duty bound, ever pray, or pass any other order that this honorable court may deem fit in the interest of justice, equity, and good conscience, and for this act of kindness, the petitioner shall, as duty
Thank you,
bound,
counsel.
ever.
Thank you.
May I sit?
Yeah, please. Respond.
Warm greetings to the Honorable Bench. If it may please, the Council seeks permission to address the bench as a Lordship.
Please proceed.
Much obliged, Your Lordship. Your Lordship, there are four main issues involved in the present case. The Council will be dealing with the first and the second issue and will be speaking for a 13 minutes. And the co-counsel will be dealing with the third and the fourth issue and speaking for a 12 minutes.
Okay.
Respectfully, reserving 5 minutes for the rebuttals.
Doesn't the 25 minutes include 5 minutes for the rebuttal? It's 20 plus 5 if I'm not wrong.
30. No, sir, it's 30 minutes.
Okay, no problem. Proceed.
If the bench is well aware with the facts, the council seeks permission to proceed with the pleadings.
Is no, I want you to give me a concise statement of facts in 2 minutes, but only 2 minutes, nothing more.
The Bake Bihari's temple in Vrindavan, Uttar Pradesh, is highly revered Krishna temple, attracting the millions of devotees annually, especially during festivals like Janmashtami, Holi, and Kartik Purnima. The temple, situated in an ancient heritage precinct, is surrounded by the narrow lanes, traditional residential structures, and century-old religious institutes, and small-scale commercial enterprises that characterize Vrindavan historical charms. On 19 August 2022, a tragic stampede occurred during the early morning Mangla Aarti, leading to the death of two devotees and injured at least 25 others.
What was
The
the reason for the stampede, council?
My lord, on 19 August 2022, tragic stampede was occurred due to the crowd, overcrowded.
19th August what?
19 August 2022.
19th August 2022. Okay. So it was due to overcrowding that the stampede happened.
Mismanagement of the crowd.
Mismanagement of crowd by?
Uh, Apologies, my lord.
No, who was managing the crowd? Council, the question is very simple and factual. Who was managing the crowd?
Temple authority.
Uh, so did this happen inside? The stampede was restricted to inside the temple premises, or did it happen outside as well?
Outside as well.
So, and who is responsible for the enforcement of law and order and public safety in the state?
There is a no proper way to go to the temple.
If there is no proper way to go to the temple, then it would have happened every day. No, what I want to come at, please understand, council, is that if an incident occurred, which was a law and order incident or a mismanagement incident, is the state responsible or not? First question is that.
No, sir. No, my lord.
So who's responsible for law and order? Please, as per Constitution of India, who's responsible for law and order in a state?
State is responsible, sir.
State, when you say state, do you mean the union? You mean the state government? What do you mean?
Pardon, my lord.
Council, are you aware of the concept of separation of powers?
Yes, sir. Yes.
What
Sir.
article does that come from?
Article 50.
Okay. Now, what are the lists?
State list, concurrent list, central list.
State list, concurrent list, center list. What list does law and order come under?
Third state list.
Thank you. So, was state involved? Was state responsible for law and order?
Yes, yes, my lord.
So, can we now go back, circle back to the point that I was trying to make and say that when there was a stampede that happened in 2022, there was maybe a negligence by the state government?
Yes, my lord.
Okay. Now, please go ahead with it.
Your Lordship, the first issue is whether the High Court mandamus under Article 226 directing a particular corridors scheme amount to permissible micromanagement of the executive policy or is a constitutionally valid exercise to remedy systematic failure endangering life and safety,
Okay.
which the Council would be establishing on 8 grounds. First, the constitutional mandate of the judiciary to protect fundamental rights. Second, doctrine of separation of power and judicial responsibility. Third is precedent supporting proactive judiciary mandamus in public interest. Fourth, principle of proportionally and reasonable measures. Fifth is doctrine of public trust and state responsibility. Sixth, doctrine of necessity. Seventh, absence of arbitrariness in judicial mandamus. Eighth is policy imperative and public interest.
Okay. Go ahead.
Now, at the very heart of our constitution lies a delicate balance between the executive and the judiciary. Separation of power doesn't mean that the judiciary must remain a silent factor when the executive abdicates its constitutional duty. On the contrary, it places a responsibility upon the courts to intervene.
So just a second. 80, TC 83, can you mute yourself? There is an echo coming from your end. Yeah, please proceed.
Responsibility upon the court to intervene when the basic rights of citizens are imperiled. The judgment of the Allahabad High Court directing the Bake Bihari Temple Corridor project was not judicial overreach but a constitutionally justified remedy. The tragic stampede of 19 August 2022, which claims innocent lives, revealed systematic failure in crowd management. Despite knowing the risk, the state failed to put forward an adequate and lasting solution. Faced with such inaction, the High Court rightly exercised its power under Article 226. I will respectfully place 8 broad submission before this honorable court.
Please.
First, Article 21 guarantees the right to life and safety. In MC Mehta versus Union of India, aired 1985, Supreme Court 946. This case held that judicial intervention becomes necessary when public health or safety is compromised. The High Court mandamus ensured that the executive does not abandon its duty but acted to secure this fundamental right. Second, separation of power is not absolute. In Keshwananda Bharti case, aired 1973, Supreme Court 1941, sorry, pardon my lord, 1461, this court clarified that checks and balances are essential when executive inaction threatens right under Article 14 and 21. The judiciary must take steps in has held in Menka Gandhi executive action failing constitutional tests are open to judicial correction. Third, proactive mandamus has precedent in Indian Council for Enviro Legal Action and Vellore Citizen Welfare Forum. This court dedicates state action in matter of public safety and environment. The Bake Bihari order follows this line of jurisprudence. It provided a framework, not micromanagement. Fourth, the principle of proportionality. The corridor scheme was a proportionate response to an imminent danger to life. Lesser alternatives, stag darshan or technological fix has already proved insufficient. Proportionality demands reasonableness, not perfection. Fifth, under
Council,
the
did you do an environmental impact assessment before deciding on this project?
can you repeat it, my lord?
Did you do an environmental impact assessment before giving a go ahead to this project?
Uh, no, my lord.
Is it mandated as per law?
Yes, my lord.
Then why did you not do it in the first place? Then what is the reason for a mandamus not to be given against your project?
So, can you repeat it, my lord?
What is the reason for a mandamus not to be given under your project to your project if you did not do the necessary environmental impact assessment in the first place?
Due to the shortage of time, my lord.
Okay, now which year are we in?
Uh, second year, my lord.
Which year is this, Council?
2025, my lord.
The incident that you cited earlier was in which year?
1955, my lord.
And then 2022, the stampede. So what you're trying to tell me is that it took 3 years and you couldn't do an environmental impact assessment, but the government was on facing a shortage of time.
Pardon, my lord.
Proceed.
Under the under the public trust doctrine, the state holds scared sides for the welfare of the public in MC Mehta versus the Kamal Nath in 1955, Supreme Court 946. This court reaffirmed that human safety is central to the trust. The corridor project fulfilled not violates that duty. The doctrine of necessity applies salus populi spexa lex. The welfare of the people is the highest law in rural litigation and the entitlement kendra. This court permitted extraordinary judicial intervention to prevent harm. Here, two extraordinary measures were essential. Seventh, Article 14 prohibits arbitrariness, not reasoned intervention. The High Court decision was based on expert reports and empirical evidence. Following EP Ropapa, arbitrariness is an anything to constitutional morality, and the corridor project is anything but arbitrary. Finally, the public interest compels the project as had in Subdas Kumar versus the state of Bihar. The right to life include a safe environment. The corridor enhance safely without eroding cultural heritage. It prevents fate while safeguarding lives. In conclusion, Your Lordship, the High Court mandamus under Article 226 was neither an intrusion into policy nor arbitrary overreach. It was a measured, proportionate, and constitutionally valid exercise of judicial power to protect life, dignity, and heritage. It represents the judiciary acting as a true sentinel on the qui vive. If the bench is well satisfied with the issue number 1, the council seeks permission to proceed with the issue number 2.
Sure, please.
Much obliged, Your Lordship. Issue 2. Whether reconfigure of the temple approaches, allays, and religious circulation routes implicates Article 25, freedom to practice, and Article 26, management of the religious affairs, and is so the correct test to distinguish faithful facilitation from the constitutional interference. May it please Your Lordship.
Sure.
The right to freely practice religious under Article 25 and the right to manage religious affairs under Article 26 are undoubtedly scared, but they are not unfettered. The Constitution itself makes them subject to Constitution of the public order, morality, health, and the larger framework of the fundamental rights. It is Precisely within this constitutional scheme that the state of Uttar Pradesh has acted, the Bakebihari Temple Corridor project is not an instruction upon faith, but a facilitation of it, and efforts to ensure that millions of devotees may worship safely with dignity and in harmony with the heritage prevention. The test as constitutionally laid down by the Honorable Court is whether state action interfere with the core religious practice or merely regulates the secular aspect of the administration. In Rave Failure, the court made it clear that the reasonable regulation does not alter doctrine is constitutionally valid. Here, the corridor project does not prescribe how Mangla Aarti or Janmashtami ritual are to be performed. It does not intrude upon theological. It is does it reconfigure unsafe LAs, provide medical facilities, create regulated entry and exit points, and safeguard the lives of devotees who gather in lakhs. This is secular regulation, not religious interference. Constitutionally, morality also depends this balance, as Keshwananda Bharti teaches us no fundamental right is absolute. If it defeats the larger constitutional purpose here to allow a hazardous, outdated layout to persist in the name of religious freedom, not to dedicate but to preserve both the essence of the worship and the safety of those who come to offer it. Your Lordship, the corridor does not dismiss fundamental rights; it strengthens them. It does not impose a
Also,
burden.
you're trying to protect some people by doing a construction on a site that is next to a river. What if it leads to flooding in, say, 1 or 2 years?
Measures will taken, my lord.
What?
Measures will taken, my lord.
Measures will be taken after floods. What if this is the reason for the flood? How do we prevent it in the first place?
It is well proposed plan.
On what basis are you saying that it is well proposed plan? What is the checks and balances that the government has done to state that this is a well proposed plan?
Expert has done assessment.
Can you show me the expert assessment report?
Pardon, my lord.
Do your facts mention that there was an expert assessment done?
Yes, my lord.
Please point the page number of the fact to me. Paragraph number and page number.
Indeed, my lord. Pardon, my lordship. The council is not aware about this fact.
So can I conclude that the expert report that you're talking about doesn't exist?
Yes, my lordship.
Sure, proceed. Then what are the reasonable measures that have been taken?
You are not audible, lordship. Can you
What are
repeat?
the general measures? What are the measures that have been taken? Please tell me that. What are the
Lordship,
measures taken by the government? Please.
lordship, my lordship. Large-scale infrastructure planning, and second is land acquisition and reallocation.
Land acquisition you'll have to do because of reallocation, obviously you'll have to do. Those are two of the compulsory measures. What are the measures taken by the government to ensure that nothing problematic happens?
Pardon, my lordship. The council is not aware about these facts.
Okay, go ahead.
Your lordship, if the bench is well satisfied with the issue number 1 and issue number 2, my co-counsel would be dealing with the issue number 3 and issue number
Sure,
4.
proceed.
Warm greetings to the bench.
Please.
Council seeks permission to proceed with issue number 3.
Sure, go ahead.
Whether the state's objective of the crowd management and public safety justify large-scale demolition and redesign of an organically evolved scared precinct when less restrictive alternatives may exist. May it pleases your lordship, at the very foundation of our constitutional order lies the state's solemn duty to protect life and maintain public order. Article 21 guarantees not just survival but the right to life with dignity, safety, and security. In the unique context of the Baki Bihari Ji Temple prison, a heritage site that has organically grown over centuries, a tragic stampede of August 2022 exposed a stark of undeniable reality. The present infrastructure is incapable of safeguarding lives. The state proposed corridor project, therefore, is not a whimsical demolition drive. It is a constitutional necessity, carefully designed, evidence-backed, and proportionate.
When you say constitutional necessity, where do you bring that from? Where does the Constitution say that that this is required to be done?
And in my lordship, would
You
you
are
please?
saying that this is a constitutional necessity. Where from the Constitution do you bring that? How do you say that this is constitutional necessity? It could be public necessity, it could be moral necessity, it could be any other form of necessity. How does it become a constitutional necessity, this action?
As my lordship, state was liable for the
For the reconstruction?
management also, sir, lordship.
Management of what?
The tragic stampede of August 2022 exposed a stark and undeniable reality. The present infrastructure is incapable of safeguarding lives.
Okay. Okay, go ahead.
First, Article 21 takes primacy. The Honorable Court in Menka Gandhi and Subhash Kumar has held that the right to life includes
What is the
right
fact of the case?
of Menka Gandhi, indeed my lordship of Menka Gandhi,
No, Subhash Kumar.
indeed my lordship, Subhash Kumar, a social worker and this journalist, filed a PIL under Article 32 of Indian Constitution. He alleged the discharge of sludge and the waste by the Tata Iron and Steel Company into the river Bokaro, a tributary of the river Damodar in Bihar, was causing severe water pollution. This pollution was affecting the right of residents to access clean drinking water and harming the environment. If the lordship is
Proceed.
satisfied
Yeah,
with the
good.
much obliged. Second, less restrictive alternative has failed. Measures such as staggered darshan and technology-driven crowd control were attempted repeatedly, yet empirical report of the state and independent agencies confirmed they failed to prevent 2022 disaster. The principle laid down in Indian Council for Enviro-Legal Action versus Union of India, Air 1996, Supreme Court 1446 is clear. When piecemeal major collapses, the structural solution became the constitutional imperative. In this third, the principle of proportionality is fully respected and expounded in Menka Gandhi versus Union of India and reaffirmed in Olga Tellis versus Bombay Municipal Corporation. This is not arbitrary state action, only unsafe or objective structure are being removed, while religious culture and heritage element are preserved. It is least restrictive and most balanced way to secure both public safety and religious practices. Fourth, statutory and environmental mandates demand this project. The Yamuna fragile ecosystem requires planned, sustainable intervention. In MC Mehta versus Kamal Nath, this court held that environment and public health concerns prevail over competing claims. The corridor integrates waste management, crowd regulation, and floodplain protection, showing responsible governance. Finally, religious freedom under Article 25 and 26 remains untouched. This project does not interfere with the rituals or access to the god. It merely ensures that darshan is safe, organized, and dignified. As Rafe clarified, pardon me, Lordship, regulating secular aspects of religious practice is not interference with religious. Your Lordship, the state stands here not as an intruder, but as a trustee bound by the public trust, doctrine of safeguard life, heritage, and environment. The corridor project is exercise of preventive governance in the line of the welfare of people is the supreme law. In the conclusion, pardon me, Lordship, the demolition and redesign of the Baki Bihari Chi prison is constitutionally
Counsel,
mandated.
just give me a second.
Indeed, my Lordship.
Yeah, please, sorry. Go ahead, what you were saying. Continue the arguments, please.
Therefore, we respectfully submit that the High Court's mandamus deserves to upheld as the only rational and unlawful, pardon me, Lordship, lawful path to protect millions of devotees and preserves the holiness of this heritage. If the bench is well satisfied with the issue number 3, Council seeks permission to proceed. Much obliged. Whether the absence or inadequacy of meaningful public consultation, residents, shopkeepers, religious bodies, and environmental experts renders the decision-making process arbitrary under Article 14. May it pleases your Lordship, the allegation of arbitrariness on the ground of inadequate public consultation does not withstand constitutionally scrutiny. Article 14 guarantees fairness and non-arbitrariness, but it does not prescribe public consultation as a mandatory ritual in every administrative action. The Honorable Court in E.P. Royappa and Subhash Kumar made it clear that the true test is whether state action is reasoned, proportionate, and directed towards the legitimate objective, not whether every citizen was formally heard at every stage. The Baki Bihari Corridor project is the product of exhaustive expert studies and crowd management assessments and technically surveys that arose directly out of the tragic 2022 stampede. These reports demonstrate beyond doubt that piecemeal measures such as staggered darshans or pardon me, Lordship, technologically monitoring were grossly inadequate to protect life and preserve order. Relying on such empirical material, the state acted in a good faith, guided by the constitutional duty, not capable. It is also important to note this was not opaque process. Stakeholders including temple authorities, local administrators, and the experts were engaged. Concern of affected people were represented through PILs, administrative consultations, and even compensation and rehabilitations under the land acquisition framework. To suggest the absence of town hall style public hearing makes process unconstitutional is to elevate from our substances. This court has consistently held in case of Union of India versus R. Gandhi and Menka Gandhi versus Union of India that fairness does not mean mechanical ritualism. What matters is the substantive reasonableness. The state has acted transparently, proportionately, and alignment with public safety
environmental protection, and heritage prevention. Indeed, constitutional obligation under Article 21, 48A, and 49 positively compile such as interventions. The corridor project, therefore, is not arbitrarily user person, but a carefully reasoned exercise of prevention governance. It secures life, respects faith, and preserves heritage, all within the framework of constitutional immorality. Far from undermining Article 14, it exemplifies its very essence, rational, uh, pardon me, Lordship, evidence-based and public-oriented decision
Council,
making.
understood your arguments. Do you have anything to add? I'll just sum up your arguments, please.
If the bench is well satisfied with the issue number 3 and 4, council seeks permission for proceed for the prayers.
Please.
Lordship, sorry to interrupt, but only 5 minutes are left to the respondents. For the
Sure.
respondents.
Sure.
In the light of the issue raised, argument advanced, and authorities cited, the council on the behalf of the respondent humbly pray before the Honorable Court to kindly dismiss the SLP filed by the petitioner Govindas and other stakeholders in entirely as being devoid of merit and contrary to constitutional principle settled judicial precedent, upholding the judgment of the Allahabad High Court, hold the absence
Okay,
or
Council. Thank you. Thank you, Council. Petitioner's rebuttal.
Metropolis Lordship.
Any rebuttals, guys? Petitioners, any rebuttals? TC 83.
For the rebuttals, 5 minutes each for the two teams.
Your time has started, team code 83. So
Sir, the respondents had agreed to that it is he is responsible to mismanagement for this crowd. If he had taken in firstly to take first decision to manage this crowd, these steps will be not be done in future.
anything else? Anything else?
No, ma'am.
That's your only rebuttal? '83. Do you have any other rebuttal?
No, not.
Okay, thank you so much.
As the statement in
No, only if you wish to respond, I'm only giving you an opportunity to respond to what they said the last, because rest responses you have already given.
Indeed, my lordship, as the tragic stampede of August 2022 exposed a stark and undeniable reality. The present infrastructure is incapable of safeguarding lives. That's why we are proposing the corridor infrastructure
Okay,
to
thank you.
safeguarding.
Thank you. Anything else, guys? Thank you. Umansh, is there anything to be done?
Yes, sir. Can you repeat?
The round is done. Is there anything else to be done?
No, sir.
Thank you, guys. Thank you so much.
Thank you, Lordship. Much obliged.
Thank you.
I
Lordship,
respect.
we
Yeah.
will be grateful if you will give us some feedbacks or something we should improve.
Sure. Just give me a second then. Are we allowed, organizers?
Yes, sir.
Sure. Thank you. First and foremost, guys, when you are addressing, you should be very, very thorough with your facts. I'll not point out anybody for anything, but I'll just keep it to very general, very generic. Uh, be very thorough with your facts. You should have the facts at the tip of your uh, tongue to be said. uh, Maximum 1 or 2 minutes, just state the facts and go ahead and proceed with it. A very important thing is that when you're citing something, even if you're not telling the citation, if it's not asked, you at least always try to pinpoint the bench to where the citation is mentioned in your memo, or maybe provide a compendium, and take the bench along and make the bench or read the page that you're reading. Just knowing what a case says is not full and final. It's important but not full and final. Take the bench along with to the requisite paras. None of you did that. Take us to the requisite para where it is stated in that specific case what you want to be read. Uh, be a bit more in terms of responsiveness, be a bit more responsive to the question that is being asked. If the question is a factual, say it's a moot court competition, facts will obviously be swayed towards both sides. It won't be towards one side. But so when the question is factual, you just state that, okay, this is as per the facts. But when a question is law related in nature and you're talking about a legal argument, then you should know the law that you're speaking. It can't be that you speak a law and it doesn't exist. And you can't argue on your beliefs, guys. So please don't argue on the basis of your beliefs. Argue on the basis of facts, argue on the basis of law. Please don't argue that you believe something need not necessarily be true. So your beliefs have to be backed by facts and laws. Okay, guys?
Thank you, sir.
I request to the participants to kindly leave the meeting room.